Good afternoon, everyone. We are pleased to welcome you today at the conference of the 12th Moscow Vice Pre-Moot. Frankly speaking, it's the first Vice Pre-Moot conference we organize after moving online. So first, let me say a few words on behalf of the organizing committee. The conference is co-hosted by the Lomonosov Moscow State University, Russian Institute of Modern Arbitration, and Young MA. We're also very grateful to our partners, KIAP Attorneys at Law, Dantons, Nektarov Savelyev and Partners, and Lidins, as well as to our supporter, Uncitral, and media partners, Global Arbitration News and TDM. Today, we have two brilliant experts in our panel, Nadia Smai and Oliver Loksa. Nadia is associate at Baer and Karrer, and Oliver is counsel at House Meininger Kletter. My name is Yulia Mulina. I'm the executive administrator of the Russian Arbitration Center and the director general at the Russian Institute of Modern Arbitration. And today I have an honor to moderate this discussion. So moving to our workshop, this year, the VIS problem deals inter alia with the issue of remote or virtual hearings under the Swiss rules. Nadia, as far as I know, you wrote an article in ASA Bulletin, Due Process under the Swiss rules on international arbitration. So please correct me if I misworded it somehow. So what do you think? Which due process considerations may arise in accordance with the Swiss rules in general and with regard to remote hearings maybe in particular? Thank you, and the floor is yours.
Thank you very much, Julia. Would you like me to answer now, or should I go ahead with the presentation first? Because I think some answers might be given as I speak.
I think that maybe the presentation is first, and then you can answer this particular question. Thank you.
All right, wonderful. Well, thank you so much for having me, Julia. It's a real pleasure to be here with you and with Oliver and with everyone who might be watching online. I will try to share a presentation I have prepared for you all. Can you see it now? Yes, wonderful. Thank you so much. So I will have the pleasure of discussing indeed today due process, Swiss rules, and online hearings. As you correctly mentioned, I recently wrote an article on this topic, due process under the Swiss rule of arbitration. I did not write it for the moot, but in terms of timing, it was a good coincidence that it's kind of useful to some people at this stage of the competition. So I will try to be quite brief because there's quite a lot to cover and so little time. So let's buckle up and let's go. So the first thing that you should see on your screen is an overview of the presentation. After a few words of introduction, I will discuss due process under the Swiss rule in general, what must be kept in mind. Then I will discuss the core of the topic, which is what are the issues at stake when discussing due process online hearings under the Swiss rules, and then a few words of conclusion. So the topic of due process in arbitration and in litigation, if you look at it from a nerdy point of view, is actually one of the coolest topics to discuss in arbitration. When doing some research for the preparation of this presentation and my article, I found that it actually dates all the way back to the Romans, who already had such concepts, so it's nothing new. Initially was created the concept of due process as a defense against the state, but now it's one of the core elements of private justice in general. As to the main components of what constitutes due process, there is not one universal definition that one could have in mind because it varies from one jurisdiction to another and depending on who's asked. This being said, I would say the two main elements relates to the right to be heard and to equal treatment. Others consider that two other aspects must be kept in mind, which are the right to have an impartial and independent tribunal and the right to receive an award with reasons. So I will briefly discuss this as well. And what is the impact and what are the practical considerations? While it is a fun academic topic to discuss, it is actually also a very relevant topic on a day-to-day basis, because it governs pretty much all arbitration proceedings or litigation proceedings. And disrespecting due process can have actual impact on the finality of the award, because some award may not be enforced pursuant to Article 5.1b of the New York Convention. And there is also a risk of challenges and set-aside proceedings, for instance, under the UNCITRAL model law, Article 34.2, with regard to the violation of due process. So it's not only cool to discuss it, it's actually a very serious thing to keep in mind. So now moving on to a few general considerations about due process under the Swiss rules of arbitration. Thanks to the magic of online hearings, I've been able to attend quite a lot of pre-moots already since the beginning of the season. I think actually one per weekend, because I didn't have much to do with my life. And in this context, I noticed that surprisingly, very, very few students brought up Article 15 of the Swiss rules in their pleading, which is actually the general provision that is relevant in almost all aspects of Swiss rules arbitrations. So this is something you may want to keep in mind in your pleadings if you're a mootee listening to this. I reproduced here some part of Article 15. The paragraph 1 basically states that the parties have the right to equal treatment and have a right to be heard. So Article 15.1 is really the major provision to keep in mind in relation to due process. I've also copied Article 15, paragraph 2, because that will be relevant, in my opinion, with regard to online hearings. And then Article 15, paragraph 7 is actually, in my opinion, an extremely important provision of the Swiss rules, because it sets an obligation for the parties and the arbitrator and all the participants to act in good faith and to contribute efficiently to the proceeding and to avoid any unnecessary costs and delays. So Article 15, paragraph 7 is also extremely important in my opinion. Then one can ask if there are any other relevant provisions that may be kept in mind with regard to due process. So with regard to these two chosen elements I've mentioned before, the right to have an impartial and independent tribunal, this can be found in Article 9 of the Swiss rules, which sets out this requirement of impartiality and independence. And you may also want to check out Articles 10 to 15 of the Swiss rules, which discuss the challenge, removal, and replacements of arbitrators. So only cool stuff. And another relevant provision that you want to have in mind with regard to due process is Article 32 of the Swiss rules, which provides this paragraph 3, that the parties have the right to have the reasons on which the award is based, an explanation as to why the tribunal decided to reach the conclusion it did. There's also other relevant provision at Articles 31 and following. And as a quick note, Article 32.3 is quite an important provision as well, because it may provide parties with more rights that they may have under the applicable law. For instance, in Switzerland, the requirements for reason is quite limited according to case law, and the tribunal only has the obligation to address the relevant issues at hand and not all the arguments of the parties, and whether or not you can have reason is also debated. So this Article 32 of the Swiss rules is something that offers an additional guarantee to the parties in terms of due process. Mandatory provisions, while there is no official or endorsed list of mandatory provision of the Swiss rules, commentators consider that some of them are mandatory just by nature, by what they state. And it's very interesting to note that Article 15, paragraph 1 on the right to be heard and on equal treatment, and Article 15, paragraph 7 on the good faith obligation are considered to be mandatory provisions. So that's something you may want to keep in mind if you're arguing something on the basis of these articles. Then very briefly, I wanted to mention the takeaways from the Swissvale Supreme Court that you can find in my article. But I basically had the idea of reviewing all the arbitration decisions rendered by the Swiss Supreme Court since 2012, hundreds of them, because again, I was worried to have no free time. And in this context, I found out that out of about 41 challenges that were brought against Swiss rules arbitration awards, only 3 of them were successful, and the award was set aside or sent back to the tribunal. And it was in both cases due to violation of due process. So for me, this still shows that the threshold for due process violation to be recognized, at least in Switzerland, is very high. And I would be interested in knowing how it is in your jurisdiction. But since you cannot talk to me, if anyone is listening, we will reschedule and discuss that at another time. And now moving on to the main topic, which is due process, Swiss rules, and online hearings, keeping in mind what was just discussed. I think in terms of online hearing and in terms of any other step of the proceedings, the provision to keep in mind is really Article 15 of the Swiss rules. The other I've mentioned before regarding the impartial tribunal and the right to reason are not directly relevant in regard to online hearings. This being said, it does state that the parties will have to be treated equally and be heard, and the tribunal should keep that in mind with regard to online hearings. The right to be heard implies that the parties during the hearing should have the right to discuss their arguments and develop their position and have witnesses if they wish. I just wanted to mention that the question of whether there is a right to a hearing as such under the Swiss rule is actually interesting, because if you look at Article 15.2 of the Swiss rules, it does explicitly provide for the tribunal to decide not to have any hearing after consulting with the parties. So it is not a given that anyone arbitrating under the Swiss rule will have a hearing. They can decide not to. This being said, obviously, if the parties decide to have a hearing, it would be extremely difficult for the tribunal to refuse, specifically based on Article 15.1 and the right to be heard. And I think this would seriously jeopardize the finality of the award if a tribunal would refuse simply to hold a hearing when the parties asked for it. Now, the right to physical hearing is another thing, because if you look at Article 25 of the Swiss rules, it explicitly provide the possibility at paragraph 4 to have online hearings. So this is, there is no right as such to a physical hearing under the Swiss rules, because the possibility of having that by video conference is provided for, again, always subject to the party autonomy and the decisions of the parties in this topic. But it's interesting to note that this article, paragraph 25, paragraph 4, explicitly provides for the possibility of online hearings. I quickly also added Article 25, paragraph 6, because during one pleading, I thought it was really cute. One person said that the paragraph 6 provided that hearings should be held in camera, which means that they would have to be held online with a camera. And actually, no, actually this means not in public. It's in Latin, and it means that you do not have to have other random people in the room doing a hearing. So unfortunately, paragraph 6 does not mean you have a right to have a camera and an online hearing. So I would say that regarding the right to online hearings under the Swiss rules, equal treatment would have to be respected in terms of listening to the party's argument, the right to be heard as well. And I would say, in my humble opinion, that a party which opposes the online hearing for no good reason, especially in the middle of the pandemic, may actually be breaching Article 15, paragraph 7 of the Swiss rules and may not respect its obligation to act in good faith or cause delays, because if both parties want to have a hearing and one of them is refusing to have it online, whereas it is not possible, it could possibly constitute a breach of its obligation to guarantee the efficiency of the proceedings and cause delays if it insists on a physical hearing while nobody knows when that will be possible again. So these are my few thoughts in the time that I have allocated. To conclude, I would say that there are a few provisions to keep in mind with regard to due process under the Swiss rules. Article 15.1, in particular regarding equal treatment and the right to be heard. Article 15, paragraph 7 regarding the good faith obligation. In my humble opinion, it is perfectly possible to have online hearing and respect due process under the Swiss rules, as long as both the arbitrators and the parties are mindful of the right to be heard and the right to equal treatment, and also mindful of their obligation to contribute to the efficient running of the proceedings. And as I mentioned before, it's a very important topic in practice. It's relevant during the arbitration, after, even at the time of the conclusion of the contracts, if the party consider various sets of rules. Most of them have due process obligations, some in more developed form or others. So that may also maybe influence which rules you choose. And I think that under the Swiss rules, it's pretty well covered, and it's a very good way of addressing the topic. So yes, I would like to say thank you for your attention, spasiba, for your time. And if you want to read more about this, I would suggest a very good book from 2020. You thought I was going to say my article, but no. A very good book from 2020, which is on due process and is on Kluber. It's edited by Franco Ferrari and others, and it talks about various jurisdictions and due process. It's a fascinating topic. If you want to have my article, feel free to write me. And if there is anything you want to discuss, I'm always happy to hear from you all. So please feel free to get in touch. Thank you.
Thank you very much, Nadia. And thank you also for mentioning this book, because we discussed due process in Russia with Franco Ferrari and New York University talk 3 months ago. So it's a really very good book, and thank you very much for your presentation. So indeed, due process considerations, they are extremely important in practice always, and now maybe especially because almost all hearings moved online. If you do not mind, we will have a Q&A session in the end after Oliver's presentation. And speaking about remote hearings in particular, so Oliver, in your opinion, have remote hearings become so new normal, default rule, or they are still the exception of the rule in international arbitration? And so are remote hearings unfair or abnormal per se? What do you think? The floor is yours. Thank you.
First of all, thank you very much. Thanks for having me. Obviously, I also have wished to be in Moscow at this time, and meeting new people and visiting a city I unfortunately have not yet visited. Instead, I'm in my children's room, as you can see from the space behind, which is convenient but not quite as exciting. So thanks for having me. Thanks, Nadia, for your presentation. That will bring me, actually, your question, Julia, will bring me to actually the topic I will be speaking about. So I'll just quickly answer it in a way. Have there become a new normal? I think temporarily. And I think certain sections of proceedings might be conducted as remote hearings or remote proceedings, parts of proceedings in future, like case management conferences, for example. I could imagine that has already been the case most in my experience. And those parts, I can imagine that they will more or less completely switch to be conducted remotely. As to evidentiary hearings, I doubt it, to be honest. I think as soon as the COVID situation is under control, I think that will mostly go back to having like physical hearings. So that to answer your question, and that now brings me to my presentation, which I hope will be visible now, or is visible now. Yes, I see heads nodding, so that means yes. So as you can see, everybody, my topic today is the general status of remote hearings. And wait a second. Yes, that brings me to my first slide, a quick introduction. I don't know who knows the Dilbert comics. People who don't know them should really start knowing them, because they are A, hilarious, and B, very down to earth, very realistic. So what has this comic to do with my presentation? Well, it shows that we have to adapt to certain challenges. Maybe, as many people saw, I think American lawyer who had the cat filter on during a hearing. So yes, we all have to learn, we all have to adapt, and I think we all have to learn how to conduct evidentiary hearings constant or more or better remotely, how to interpret witnesses, how to ask questions without actually being present. That having been said, I think the general status can be summarized generally quite easily. It's probably fair to say that the case law generally accepts remote hearings as being fair and not in violation of due process. I point to 3 decisions. Proudly, I point to a decision by the Austrian Supreme Court, which many people certainly know already. It has been widely discussed, also by me. I think, yes, I don't want to spend too much words on that decision. Most people will know it, and I'll talk about it later as well. Suffice to say at this point that the Austrian Supreme Court did not see any general problems with conducting remote hearing or conducting evidentiary hearings as remote hearings. The same can be said about the US case I mentioned, that is on the slide. I will come back to that as well. And then we have an Egypt case which felt, or an Egyptian court felt actually obliged to point out that in international commercial arbitration, hearings are not always conducted at the certain places. They are conducted all over the world. They're not restricted to the seat of the arbitration. And that also basically applies to the possibility to have remote hearings. As we also probably all know that institutional arbitration rules have been amended and adapted accordingly. There have been either the rules themselves or there have been some notes. So I think it's fair to say that also the institutions have taken all of the current situation and into account and are planning for the future. And also the IBA rules, which have been published in February 2021, have a remote hearings provision. Just a sidestep, very interesting, they also have a provision on the possibility of tribunals to exclude evidence which has been obtained illegally. Just off topic, but I find it interesting. So, but that obviously is not it. It's very boring if we stop here. So let's look at some food for thought. So are remote hearings generally unfair? I just covered that. I think it's fair to say no. But what about, is there a right to a physical hearing, or is there a right to an oral hearing from which a physical hearing can be derived? Now, there was a very interesting survey by the ICCA, which is publicly available online, that covered many jurisdictions, I think over 20 jurisdictions, where lawyers basically demonstrated the status of remote hearings in their jurisdictions. And most model law countries do not have a provision from which it can be either explicitly or implicitly derived that parties have a right to a physical hearing because there might be a right to an oral hearing. Whether there is actually a right to an oral hearing or under which circumstances is a different story. Couple of exceptions like Bahrain, Denmark, and Vietnam apparently, where it is a bit disputed. But I take from that survey that also in those jurisdictions, the situation is moving. What is interesting, if you look at Article 24, 25 of the model law, for example, but also other arbitration codes, there's always the the expression, the term to attend hearing, to appear at hearings or oral hearings. And obviously that raises the question whether that means that there has to be a hearing in personam. And it's fair to say that that can be most likely not seen that way, that it can be negated. Attending a hearing doesn't mean that everybody attends the hearing at the same time, at the same place, as is the case with appearing at the hearing, or an oral hearing is, as also Nadia pointed out, not necessarily a physical hearing where people come together. And the US court decision I mentioned before did address that issue, and it very clearly said, well, attending appearing, I mean, everybody's attending appearing, just remotely. And it also covered the question, what about the issue of there being a location where people meet? And it said, well, you are at a location when you log in from a remote place. So those arguments, those potential arguments, they have not been followed or were not followed by the US court. But yeah, I mean, obviously it is open for interpretation, discussion, I would say, but it's certainly a difficult argument to make. Now, what if there's an agreement by parties to have in personam hearings, physical hearings? I wrote down show me because frankly, I have not come across one so far in my experience. Certainly my, I don't know, 10 years of experience is not 100 years of experience, but and I'm sure there are those agreements. I personally have not seen one. The different story, of course, is what are the consequences if there is an agreement and the tribunal disregards that agreement. Again, pointing to the ICCA survey, there seems to be very different consequences in different jurisdictions. In some jurisdictions that could lead to an annulment of the award. Then it depends on when the agreement was, when it was agreed on that there should be a physical hearing. In other jurisdictions that would not lead to an annulment of an award, and so on and so on. So I just wanted to point that out. That is a very tricky issue and has to be decided basically jurisdiction by jurisdiction. What happens rather frequently, and again, I point to the Supreme Court decision, what happens if a party actually objects to a remote hearing and says that it wants to have a physical hearing? I personally was administrative secretary in a recent proceedings where that happened. And the tribunal decided to go ahead with a remote hearing under Austrian law, as the Supreme Court decision not an issue, simply because that can be derived from the Article 6 of the ECHR. Justice delayed is also justice denied, and the tribunal has also to have take into consideration that it cannot prolong proceedings until who knows when. And that was the same ratio used by the tribunal in the case, in the proceedings I mentioned. It's just not foreseeable when we will have the possibility to have a in personam hearing. But of course, that is a tricky decision, and I think that a tribunal always has to take into consideration weighing balances. How long would the process be postponed, and so on and so on. In other proceedings in which I'm again administrative secretary, the hearing is supposed to take place in June 2022. Sorry, and for the time being, we are sticking with a physical evidentiary hearing, although it's overseas, so to say. One point I want to point out, because I read it in a conference report and I find it very interesting, especially for us lawyers, we have to consider, and sometimes we might forget, that parties are not lawyers, or CEOs are not lawyers, and they might have different expectations when they draft an arbitration agreement, which is not drafted by lawyers. Mr. Gabriel Costa, who apparently is from the Shell company, the oil company, he said that, well, if they have an arbitration agreement which provides for a hearing to take place at a certain location, which is the case in the Pre-Moot problem, then they do expect that the people actually will come together at that location and have a physical hearing. So that is something which Moody's listening might take into consideration. We have to keep in mind if an agreement was drafted, conducted, signed by not lawyers, by parties, that they might have had certain expectations and they might not have known the recent decision of, I don't know which court, stating that providing for a location does not mean that you necessarily have to actually be present at that location. And finally, just quickly pointing out to, well, litigation. Why am I saying that? Because even though we probably all agree that state court proceeding rules, like civil proceeding codes, do not apply in arbitration in most jurisdictions, I know at least. Rules from state court proceedings, from litigation, are still often being used to demonstrate why arbitration proceedings, arbitration decisions should be made in a certain way, and the decision should be a certain decision. Again, pointing out to a case I had, that was the case when it pointed out, when the argument was made that in Austria, state court proceedings, in general, you still have the physical hearings, evidentiary hearings. And in times of COVID, it was obviously adapted and amended slightly, as saying that if one party objects to remote hearings, you still have to have physical hearings. If both parties agreed, and it can be a remote hearing. And then basically it was being used as an argument. It did not fly, to be honest, with the tribunal. But I want to raise the idea that the ratio of certain litigation rules, of codes in litigation, while it's not strictly applicable in arbitration, are still something that might be looked into when arguing, as I said, the ratio behind of that. Having said that, that brings me to basically my conclusion. I hope that I was able to provide you with a bit of a general overview on the issue of remote hearings in arbitration, and I hope I was able to answer your question, Julia. As also Nadia pointed out, if there are any questions, please feel free to ask them, to write me. I think it's a very interesting topic. I think it will accompany us for quite some time, and I'm sure the arbitration community is quite creative when dissecting certain topics, and I mean that as a compliment. I'm sure that with the general status of remote hearings not being unfair, that is not it. I think there's a lot to come when parties will argue why in certain situations the hearing should not be conducted remotely, but in person. Thank you very much, everybody, for listening.
Thank you very much, Oliver, for your presentation and, of course, for this food for thought. So for summing up your thoughts and your presentations, and speaking of due process and remote hearings, may I ask you both, may I ask the same question as in the beginning? So what type of due process violations can occur with regard to remote hearings? So let us start in the same order with Nadia, and then Oliver. I'm so sorry, we have only 5 minutes left, so let us be rather quick.
Okay, so I will try to cover a violation that hopefully Oliver would have thought about as well. But as I've mentioned, I think that it's perfectly possible to have an online hearing without breaching due process. This being said, I think that in terms of right to be heard and equal treatment, it could be imagined that a tribunal does not give the floor to some parties, and in terms of equal treatment, that they are not given notice in advance. And then without some imagination, you can obviously go very far and imagining very interesting violations, such as, for instance, not providing the link to the hearing to one party but to the others. So that would be a violation of equal treatment. And you could also imagine that the tribunal would never unmute a party, but only let the other speak. So that would also be a violation, or that the tribunal would force the party to wear cat filters and not the others. I mean, anything can happen online. So I would say that there is due process violation, but if you look at the one that I think would come to mind directly, it's absolutely possible for a tribunal to respect due process, even in the framework of online hearings. So I hope that answers the question.
Thank you, Nadia. Oliver?
Yes, I completely agree. I think I can imagine that there could be witnesses which are so important to a proceeding that a party points out, look, we really have to have that his testimony and cross-examination and so on, and in personam. That I could imagine, and I think all the other stuff people will like the reasonable problem technology and that, yes, I can imagine that being a problem, although now I recently had a case management conference from all over the world and it worked. But I can imagine that in evidentiary hearings, that could become tricky. I think what could arise is what if an evidentiary hearing being conducted has problems, like technology doesn't work or whatever, so that you don't have the due process violation maybe in advance already, but it appears while the hearing is conducted, and that then a tribunal would either have to stop it and reschedule, or to conduct it at a different, either again remotely maybe in a different way, or physically. I think that could become an issue, but with technology getting better and better, I hope that will be solved.
Thank you very much. Thank you very much, Nadia and Oliver. So I'm so sorry, our time is almost over. So just let me thank you for very interesting thoughts and ideas. And I hope that maybe in the future, if we have more asynchronical, for example, hearings or hybrid hearings or remote hearings, everybody and all the tribunals and all the bodies will try to do it the best way without any violations of due process. So in 5 minutes, I'm so sorry, the session on CISG applicability starts. So stay tuned and thank you very much for your attention. And of course, good luck to all teams tomorrow and on Sunday. Thank you very much. And thank you very much to Nadia and Oliver, first of all.
Thank you.
Thank you.
Bye.
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 Good afternoon, everyone. Welcome to the session number 1 of the conference organized on the occasion of the 12th Moscow Pre-Moot. It is my pleasure as the moderator of this session to introduce to you the exquisite panelists we have today speaking on new rules for vaccines, CSG and its extension to licensing agreements. I'm sure that neither of my 3 panelists requires any special introduction, as you have heard their names and read their books on many occasions, I'm positive. But just by means of brief introduction, we have Professor Schwenzer with us today, who is one of the leading authors in the field of international commercial law, and whose 2 perhaps biggest achievements, if one can deduct a biggest achievement in her rich career, are the publications or commentary on the CSG, which was initially co-edited with Professor Schwenzer, and now she stands as a sole editor and contributor, one of the contributors, and her book on global sales and contract law. We also have Professor Lucas Mistelis, whose comparative arbitration law book I'm sure most of you have read and quoted in their legal submissions and academic writings, and again, which stands only as one of many of his publications that are particularly important for the field of international law, but also international private law as well. Professor Andrei Shervint is the 3rd speaker we have today with us, and again, who requires no special introduction. His favorite child in terms of publications is his book on the role of fictions in Roma law, which is used as a literature for many of you studying in Russia or where Russian is a language of instruction. Of course, these are not the only publications my dear colleagues have written and prepared for you in the past, and it's very difficult to list the number of publications they have had so far, and I'm sure they will have many more in the future. But it's important to say that not only are the 3 of them involved in academic work in their respective universities in Moscow, Basel, and London, but they also have a vast practitioner experience. All 3 of them regularly act as arbitrators, both in commercial cases and in investment cases. Thus, I cannot picture 3 better persons or speakers to share their knowledge with us on the topic of our today's panels. And last but not least, it is worth mentioning that 3 of them together speak 9 different languages, and neither one of them speaks less than 5, which also tells you that the literature that they are using in the research and the end product arising out of such research is highly commendable, as it indeed covers all relevant jurisdictions throughout the world. So with this brief introduction being said, I will guide you through the topic of today's panel by asking specific questions to our panelists and leaving the floor for discussion to you as well. You can use the chat function and pose questions to our speakers, who will later, upon their presentations and providing me with some of my pre-prepared questions, also provide you with the answers to the questions. So starting with Professor Schwenzer. So today we are supposed to talk about licensing agreements, mixed contracts, services contract, but then again, the topic of our presentation is the CSG, which in its name has a mention of the sales contract. It has been a document initially assumed to cover the area of international sales. Yet in today's world, the trade includes so many services contracts and dealings cross-border. So how do we, why is the CSG limited to sales convention? Why have the services been excluded? Are they excluded indeed?
Thank you very much, Milena, for this kind introduction. Let me first thank the organizers for organizing this Moscow Pre-Moot and this conference. Milena, you're asking me, why is the CSG a sales convention? Why is it excluding services? Well, that must be understood against the historical background and the background of the domestic legal systems. In all legal systems, in civil law countries as well as in common law countries, we distinguish between sales contracts and services contracts. In civil law jurisdiction, this goes back as long as Roman law. Andre certainly knows about that. But also in common law, if you look in common law, since the 19th century, there have been statutes codifying contracts for the sale of goods, but there are no similar statutes for services contracts. So it is a clear distinction in domestic legal systems between sales and services. Nobody ever thought about including services in the CISG. It was not until the Vienna Conference in 1980 that there was a proposal, actually a proposal by the Czech Republic, to also conclude services into the scope of the CISG. But this proposal was immediately rejected, and I think not because the CISG would not fit service contracts, but rather because we never discussed it before, and including services contracts would have jeopardized the whole idea of unification of sales law. So this is the background why the CISG is a pure sales convention and does not include services.
Thank you. Thank you so much for this historical overview and the overview reasons why this is the case. But then again, we do have Article 3 of the CISG. What is its scope? What does it cover?
Indeed. And Article 3 is a great achievement. If you compare it to domestic legal solutions, it's really a great achievement. It delimitates sales contracts from contracts for work and labor on the one hand, that is Article 3, Para 1, and sales contracts and contracts for services. If we come to the conclusion, and I will explain how we distinguish between sales contracts and services contracts, if we come to the conclusion that a certain contract is governed by the CISG, then the achievement is that the CISG governs the whole contract. It does not distinguish between sales and services obligations, but treats them alike with consequences like, for example, if there is a deficiency in the services obligation, then the buyer must also complain about that. It must notify the seller of any shortcoming in the rendering of the services obligation. So it's quite difficult. The Article 3, Para 2 only mentions services. So Andre will address the question whether also other obligations than services can be treated like services under Article 3, Para 2 of the CISG.
Thank you. But so what is the relevant test? I mean, Article 3.2 does involve a test which tells us the answer to the question of whether the CISG applies even if there are services involved or the services obligation involved under the contract. Can you tell us how has this test developed in case law and doctrine, and what does it provide?
Article 3 talks about the preponderant part, but be precise, read Article 3, Para 2 of the CISG. Actually, many of our this year Wismutis didn't read it exactly, because what is the wording? The wording is that the convention, the CISG, does not apply if the preponderant part of the obligations consists in the supply of labor or other services. It says it does not apply if the preponderant part are the services obligations. It does not say the CISG applies if the preponderant part is the sales obligation. So we have to look at the importance of the services obligations in comparison to the other obligations. Well, how do we determine what is a preponderant part? Well, actually, there are different approaches. The prevailing view nowadays is, that was also voiced by the CISG Advisory Council in its opinion number 4. It is that we primarily look at the economic value of the obligations. So the economic value can be spelled out by the parties in their contract. I have seen many mixed contracts where the parties explicitly said the price is 80% of the price are for the sales obligations, 20% are for the services obligations. If the parties have not determined this in their contract, then we have to look at it objectively. And if it's not possible to determine the economic value of the sales obligations on the one side and the services obligations on the other side, then we must look to the intention of the parties. And the intention of the parties might be expressed, for example, in the wording of the contract. So many of our Vis-Mooties who are participating will have thought about that. What are the interests of the parties? What is the core of the contract for the parties? Is it the sales obligation or is it the other obligation? Article 3, Para 2 speaks about the service obligation, and Andre will address the question whether this can also be a licensing obligation. So, and what is preponderant? Is it 50.5% or what is it? Well, the majority view today is that it must be clearly imponderant. So it must be, the services obligation must be significantly more than 50% in order to bring the contract out of the CISG. Otherwise, as I said, and that is very important, the CISG governs the whole contract, including the services or other obligations.
Thank you. Thank you so much. And this already answers one of the questions we have received from the audience, and that is how to determine the preponderant part for mixed contract. When the parties have not specified which of the obligations bears greater significance. So thank you for that. But I'm also interested to hear something about the rules of interpretation. Are we, while deciding whether the CSG applies or not on the basis of the Article 3.2, are we using the Article 8 test for interpretation of what parties intended, or do we have different tools for interpreting the contract?
Certainly, this is always the first question. What did the parties indeed intend? And under Article 8, Para 1, we ask about the common intent of the party, which is always not easy to determine. If not, we go to Article 8, Para 2, and ask what would a reasonable person in the shoes of the parties have thought by introducing such a term into the contract. And what is also very important is always Article 8, Para 3 of the CISG, namely that we have to take all the circumstances into account when interpreting the party's behavior or also the party's contract. So this is always core, and only if we cannot find out what would a reasonable person have thought by introducing these terms into the contract, then we move to a more objective view and ask what is objectively the preponderant part of the contract.
Thank you. Thank you so much. And this kind of leads us to Andre and to his presentation today and some of the questions I would like him to answer. So we see that there are still many uncertainties under the CSG. Ingeborg has told us what is the current status of affairs when it comes to academic writing and case law on interpretation of preponderant part in Article 3.2 or on the tools for interpreting the parties' agreement. But is there something that the parties can do in advance to cope with these uncertainties? What would you say on that?
Thank you. Well, yes, it is often stressed in the commentaries, but in the UNCITRAL legal guides as well. For instance, in the UNCITRAL legal guide on construction contracts, that in these gray zones, in the cases where the material scope of application of the CSG might be subject to debate, the parties would be well advised to meet explicit provisions on that. that might be true, but it is well known that there is much more than just one way in which parties' agreements affect the applicability of the CSG from the point of view of the material scope of application. Clearly, the most obvious option available to the parties, and the only one expressly provided by the convention, is to exclude the application of the convention to the contract, which would otherwise fall within its scope, Article 6. The tools of private autonomy, not explicitly recognized by the convention, are opting into the CSG through the choice of law and its incorporation into the contract as contractual terms. All the mentioned contractual dispositions, immediately concern the applicability of the convention. But above that, one can identify an array of issues where the applicability of the CSG depends ultimately on parties' choices as to how to frame their contractual relationship. For instance, it is for the parties to decide whether they prefer to enter into a single mixed contract with sales elements in it, or to conclude two separate agreements, one of them being a contract for the sale of goods. These are cases where the applicability of the CSG does not amount to the primary object of the respective agreement, and yet the choices made by the parties will bear heavily upon the applicability. The effects of these agreements differ in many ways, in many aspects. They are mainly the capability of the CSG to prevail over the mandatory rules of the otherwise applicable national law. The second one would be the applicability of Part 2 of the Convention, as well as perhaps of its Article 8. And last but not least, applicability of the gap-filling rules of the Article 7.2 of the CSG. Let's stick to the example of the mixed contract. If the parties decide to include an only insignificant obligation to supply services into a contract for the sale of goods, this contract will be, by virtue of Article 3.2, under the convention. Part 2 of the convention applies automatically, and the CSG prevails over the mandatory rules of otherwise applicable domestic law. On the contrary, the same parties can take another option and conclude separate services agreement with a clause that the contract shall be governed by the CSG. Both issues under consideration, that is to say, the applicability of the Part 2 and the precedence of the convention over domestic mandatory rules, become much more complicated, as is generally known. I see three problematic issues concerning this several types of parties' agreements that bear upon the applicability of the CSG. First, interpretation. What has actually been agreed upon by the parties? Does the agreement at hand qualify as a choice of law, as an incorporation by reference, or does it merely envisage the content of the contract? Staying with the example of mixed contracts, one could imagine a contractual clause expressly stipulating that for the purpose of Article 3.2 of the Convention, the obligation to supply the goods shall be deemed preponderant. Is it an agreement on the content of the contract or an opting-in clause? Second problematic issue would be, in my view, reinterpretation. it will be often advisable for the court or the arbitral tribunal to uphold the validity of the parties' agreements to the extent possible. Thus, if the court will be reluctant to acknowledge the choice of the CISG as applicable law, it might reinterpret the choice of law clause into incorporation clause. Whether this happens depends strongly on the position of the applicable law and the circumstances of the case. And the third problematic issue would be the ambit of the private autonomy as regards the agreements concerning the content of the contract. For instance, is it absolutely up to the parties to decide whether the agreements at hand form a single mixed contract or separate contracts? Or is there a kind of interplay of objective and subjective criteria? What if, let's say, parties to a contract for the international sale of goods enter into a minor service contract unrelated to the first one and make an express provision that this new contract shall form part of the previously concluded sales contract? Would the new contract fall within the scope of the CSG through Article 3.2? All in all, I wouldn't perhaps go so far as to speak of new uncertainties connected to the parties' agreements. But for sure, there are many issues here that deserve serious attention of the parties. That would be my answer to this first question in general.
Thank you, Andrei. And I see that that you have indeed opened up some of the new uncertainties as well, on top of the ones that we have noted previously. But is there a way, or what would your suggestion be, how to close the uncertainties or eliminate them? What can parties do in practical terms out of these options that you have mentioned? What do you think is the best or most viable solution to put some certainty on the legal qualification of the contract and the applicability of the CSG?
Well, at least the parties have to approach this issues with open eyes. They should see the risks that their choice of law clause will be reinterpreted in light of the national law of the court or arbitral tribunal. And they should obviously be perfectly aware of what they are doing. Are they really restructuring their rights and duties under the contract, or choosing the applicable law? And I think that that will be at least not eliminating the risks, but seeing them, but assessing them.
Thank you. And we spoke in advance to this panel. We spoke about the topic for the panel and how, the relevant question being asked is whether the CSG can be extended to licensing agreement. So what's your take? Does CSG already cover licensing agreement, or does its application needs to be extended? And if so, how can a private party autonomy play a role in this case?
Well, let's start with the contract that is a purely licensing agreement, which, as I see the prevailing view, doesn't meet the requirements of Articles 1 and 3 on the substantive scope of the convention. The parties have at first two options: the choice of law clause and the incorporation clause. Of course, the choice of law clause, choosing this way would be subject to thorough analysis of the position of the applicable law on depending in particular on whether state court or arbitral tribunal will be hearing the cases and the common stance of the respective domestic legal system. By the way, the Russian Supreme Court has 1.5 years ago acknowledged that the rules of law can be chosen as applicable law, explicitly mentioning PICC, PECL, and I think DCFR. I'm not sure now. The main drawback of both options, but mainly the main drawback of the incorporation option would be that the CSG will not enjoy precedence of a mandatory rules of the applicable law. And as some comparative research reveals, the amount of the mandatory rules concerning licensing contracts differs strongly across jurisdictions, and in some countries might be considerable. And as far as the choice of law option is concerned, what one should always bear in mind the risks that it would be reinterpreted in an incorporation clause, and then the drawback is again here. So the mandatory rules on licensing agreements that might be a great deal there would apply, would have precedence over the parties' agreement. If, however, the parties are about to enter into a complex deal that encompasses not only licensing agreements, but typical sales elements, as well as the applicability of the CSG might depend on whether they decide to form a single mixed contract or separate contracts. It is absolutely up to the parties at first. Furthermore, the preponderant part, as Ingeborg has already mentioned, the preponderant test of Article 3.2 cannot ignore the parties' agreement as to what of the obligations play the leading role. So the parties may attach more importance to the licensing elements, and then the preponderant test would lead to automatic application of the convention to the contract. However, I still see doubts as to whether the parties are absolutely free here. Ingeborg has mentioned contracts where parties explicitly state that the sales elements are 80%, the services elements only 20%. But would we regard it as falling exclusively under Article 3.2 if, in fact, the objective values would be vice versa? If the sales element is objectively measured, but a peppercorn in the whole structure of the parties' rights and duties, would the parties be able, by their agreement, to alter this equilibrium radically? Or in this case, if objectively the services part would amount to 80% and the sales part only to 20%, their agreement to the contrary would be qualify not as addressing the content of rights and duties, but rather as the choice of law or the incorporation clause. That would be my doubt. But to sum up, choice of law, incorporation clause, and an explicit agreement as to preponderant test. That's, I think are the options that the parties have as far as the licensing agreements under the CSG is concerned.
Thank you. Thank you, Andre, so much. And I'm looking forward to hearing Lucas's take on the matter of whether CSG applies to licensing agreements. But before I give the floor to Lucas, if I may just read the question from the chat to all of our speakers for you to think about it until the second round of comments. So what our colleagues are asking is whether we should take into account all obligations under Article 3.2 test, including the conditional ones, the optional obligations, or only the ones which are effectuated or which will be effectuated for sure in the future. So keep this question in mind. And but before answering it, Lucas, what's your take on licensing agreements and CSG?
Milena, you're raising a very important question, of course, and also a question which is very relevant for this year's moot. And I think what we have heard from Professor Spencer and Professor Shirvid are all very important points. I think there are perhaps two different ways to approach this question. One is to approach it by strictly looking at the CSG and its text. And therefore, one should be looking at Article 3, a mixed contract with sales and other elements. But perhaps, I would admit, one should also be looking at Article 4, which suggests that the CSG only regulates aspects of contracts of sale, but not everything about the contract of sale. Article 7, which anticipates that there are matters that are not covered by the CSG and they will go outside. And of course, Article 8, which brings it back to the will of the parties. So one can just work on a sort of a textual interpretation of the CSG, and one should not be opposed to even a dynamic interpretation of the CSG. I think Ingeborg Schwenzer makes the important point that the CSG captures negotiations which have been ongoing in different forms from the 1930s, perhaps, predecessors of the CSG to 1980. And then at the time, there's a very good point where there's an agreement and the text is fixed, and the text is fixed where parties felt strongly that, negotiating party states, they felt strongly that that's the way to move forward. And in that sense, the CSG is a major achievement. If one brings into that discussion dynamic interpretation of treaties, perhaps could really extend and expand the CSG to contracts which have not been anticipated or have been anticipated but not expressly covered. So that's one way of looking at it. The other way of looking at it is perhaps by looking at contractual language and intention of the parties, which of course the CSG takes that into account as well. But where I think I would like to make perhaps a slightly different sort of take on the discussion is we have been for many years focusing on a mixed contract or a single contract. And if one looks these days, complex contractual arrangements, I don't do counsel work, but people who do, including my wife, for example, they will see that in a particular sort of complex arrangement, you have a framework agreement, which will have a lot of different things, and then there will be particular purchase orders, which are mini sales contracts. There will be particular sort of agreements on obligations of the parties and a series of annexes that will cover licensing and all of that. So I wonder that we have been trained to see that framework agreement or mixed contract as a single contract. And I'm not sure whether this is correctly seen, even from the perspective of the parties. It might in some cases, parties feel that they conclude a series of agreements which are being activated at different parts of the life of the contractual relationship, rather a single contract. I do understand, and I do have a lot of sympathy for the argument that the single contract argument is a better argument, but it's an argument that will be inevitably stretching the language of treaties and the language of contracts. But if one were to accept sort of and if one be excuse the French term, a dépêchage, there are multiple contractual obligations subject to different regimes, maybe then one comes to a different outcome. So that's not a very good moot answer, because the moot answer you have to answer with a yes or no, and then you can explain. But my feeling is that while the CSG anticipates licensing arrangements, particularly in Article 42, I don't think the CSG as such extends to licensing agreements, where we have primarily a services element and not a sales element. That's the short answer.
Okay, thank you, Lucas, so much. So, and you mentioned Article 7. How does it help us in this analysis? And then again, going back to party autonomy and Andre's presentation, what can the parties do to make sure that the CSG applies to their licensing or predominantly licensing agreement?
I think both Andre and Ingeborg, and I don't think I will disagree with that. If the parties want to make the CSG available to their entire contract, they have the capacity of doing that. And I think even systems which are a bit more conservative in that sense, particularly common law systems, they will accept incorporating rules of law contract, but then as contractual terms, not as law. But these contractual terms will be given validity by an adjudicator, whether it's a tribunal or a court, to the extent that they don't contradict with mandatory provisions. And in that sense, and I think that's actually something that it is mentioned in our book that you mentioned, is that the CISG has the capacity of being rules of law, even where it's not applicable as law. So Article 7 does not necessarily accommodate that option, because Article 7 would try to have a conflict of laws analysis in filling the gap in an area where the CISG would not cover the contract, and where an adjudicator will have to make that determination. And of course, Article 7 is iconic and is very, very significant, as significant as Article 8, because it does indicate that we need to fill the gaps, having regard to the international character, of course, and the need to observe the good faith in international trade. But for all the matters that are not being covered, it has to be done in accordance with private international law. And private international law, you take it as you find it. If you're in arbitration, you have a predominantly more liberal system where the parties can choose rules of law. In some systems, arbitrators can choose rules of law that they deem appropriate. But in some systems, arbitrators do not have that possibility. They have to more narrowly operate through a conflict of laws system and land to a national legal system, which might be part of the CSG or not. And perhaps I should like to mention a case here. There have been a couple of cases, of published cases, with license agreements in Stockholm arbitration. And in almost all of these cases where there were sales and license elements and even counter licensing arrangement, in that particular case, and the tribunal have decided not to go for the CISG, but to go for something else. In this particular case, the UNIDROIT principles, because they thought that every attempt to bring it to a national law, and given that some systems had the CISG, some systems did not have the CISG in operation at that time, it's an older case, applying a neutral standard is perhaps a more attractive proposition for a tribunal than trying to localize a dispute with the most closely connected law. Of course, I have to add that Scandinavia and Sweden has this doctrine of negative conflict of laws, which means where the parties could have chosen a law and they did not choose it, they deem to not have wanted to have it applicable. But that's a different question for another time.
Thank you. And this, to some extent, answers the third question I had prepared for you, and that is this distinction between the law and the rules of law, which is so relevant for application of in the private contractual relationships that have an international element in it, and a distinction between how the court would decide which law or rules of law apply and how the arbitrators would decide. And in most countries, the private international law rules take us inevitably to the law, which is often considered the national law. And here I hear Andrei has mentioned that the Russian Supreme Court has recently applied CSG as rules of law within the court system, or is that something else you had in mind? And then we'll go back to Lucas.
I think Andrei confirmed that the Russian Supreme Court has confirmed the rules of law as a source rather than law, but not the CSG specifically.
Right.
Correct, Andrei? Yes. Yes. I think this is this is where we owe a duty of debt to the French culture and the French legal system. I think the whole debate of rules of law comes back from the French arbitration law in many years back, not the current version, but even in previous versions, where tribunals were allowed to apply rules of law rather than law. Of course, the distinction is, perhaps for students, not for us, is that when we refer to a law, we refer to a legal system, the whole package, the text, the interpretation of the text, the jurisprudence, the case law that goes with the text. While rules of law relate to formal or informal codifications, whether there's Incoterms, whether there's UCP 500, UCP 600, whether there's Unidroit principles or anything of that type, which doesn't have a formalization or a legitimation through being adopted in a national legal system. Now, the French and then the ICC rules historically have been very liberal in accepting the rules of law. The Swiss rules as well. That's perhaps bringing more to come to the moot. And this has expanded even in systems which were historically a bit more conservative. For example, the ancestral rules. But you still have many legal systems, particularly common law legal systems, that they do not accept the rules of law as a source of law for adjudicators to take into account. And this perhaps is attributed largely to Dicey and Morris, which is, for better or worse, the restatement of conflict of laws in England since the late 19th century. And they only allow filling the gaps from within a legal system rather than rules of law, because rules of law are deemed to be incomplete. Having said that, there has been, by a number of colleagues, academics, by a number of practitioners, attempts to give more content to rules of law, that perhaps the original Dicey and Morris argument doesn't stand as strong as it did historically, but that hesitation it exists, and I think the only way out is either arbitration rules or arbitration laws. I was thinking, for example, Lithuanian law that I was studying recently for something different matter, which have this open entry to rules of law, and there one say lex mercatoria, which for me is a wrong terminology. I think lex mercatoria has a historical context. I would like to use as a modern term transnational rules. So that is widely possible in arbitration, but not everywhere. Read the rules and read them carefully. But is less possible in some legal systems, and certainly in relation to judges in common law. Civil law is different, and therefore in common law, rules of law can only have a contractual value. Sort of, they've been deemed as contractual stipulations and nothing else.
Thank you, Lucas. And this adds to a number of items parties should check in their negotiations of the international transactions, because it's not sufficient for them to think about, whether the CSG would apply or not without their express stipulation. They should also think about the country in which they want the dispute to be resolved and whether it should be before the court or arbitration tribunal. And then again, what are the relevant rules for the applicable law under the rules of that specific arbitration institution and lex arbitri. But let's take another round through our virtual room and see whether there's something to be added and commented on what the rest of you have spoken about. And then again, if you would like to answer the question posed by the audience on, these optional conditional obligations from the mixed contract, where do we evaluate them? How do they contribute to the predominance of service obligations or the non-predominance of sales obligation? Ingeborg.
Yeah, well, my first consideration would be whether it's one single contract or whether we can discern two separate contracts. And if we have two separate contracts, one with actual obligations and the other one with conditional obligations, then I have to look at each of the two contracts separately. This is clear, and decide whether the services obligations or the licensing here is the preponderant part or not. If we do have one single contract, then I would tend to include the conditional obligations as well. And I would look primarily at the economic value of all the obligations. And then I would also look at the interests of the parties. And if the interests of the parties are primarily directed towards the conditional obligations, and the other part of the contract, the actual obligations, are just kind of preparatory obligations to obtain the final result the parties are aiming at, then I think it's clear to include the conditional obligations, and then to ask the question, so is that predominantly services obligations, or is that predominantly sales obligations? So that would be my answer to this question.
Thank you so much. I mean, do we have other comments from the room? Andre, would you like to contribute to this particular topic, or to add a comment to what Lucas was saying earlier?
I'm also inclined to say that the conditional obligations have to be considered within the analysis under Article 3.2. Well, a conditional sales contract would inevitably fall under the CISG. So I don't know why a conditional part of a contract would be dealt with otherwise. Perhaps an objective perspective could be taken in some cases, and one could ask whether the conditional obligation is, well, objectively connected, related to the unconditional one. But I'm not sure. I'm just guessing here. If I'm thinking, if the obligations of the parties, the unconditional, the simple ones and the conditional ones, form a clearly carved deal, economic transaction that speaks for consideration of the conditional part. If the conditional part is not related objectively to the simple obligations, perhaps one could in some cases say that then it shouldn't be considered. I'm not sure.
Thank you. Lucas, would you like to add to this topic?
Yes, I mean, I have to say that this particular question is perhaps very much moot related, and I'm not sure whether the intention is really to cover conditional sales as such, or the option to purchase, as the particular moot problem has this, for example, develop a vaccine, and if the vaccine proves to work, then you can perhaps opt to buy, but you need to have the license just in case. We'll do that. I think that perhaps puts an additional gloss as to whether this is generally a conditional sales contract or some slightly different beast. And perhaps the other thing that we have missed out of the discussion is to what extent party autonomy is manifested by the way parties label the contract. I use the word framework agreement. This year's problem calls purchase, cooperation, and license, which has, of course, perhaps arguably three broader obligations described in the title, one could think of different names. And I know nomenclature perhaps is not too important, but I wondered to what extent that might be an indication of parties' intention. And I would put I would throw that into the list of criteria that we have to consider.
Thank you. And indeed, Ingeborg, what would you say? To what extent does parties' nomination of a contract contribute to the interpretation and conclusion on the legal qualification of a contract?
First of all, I wanted to emphasize that it's always up to the parties to design their contract. And also, I think we slightly are of a different opinion, Andre. And if they want the CISG to apply, then the CISG must be applied, no matter if objectively it's not a sales contract. So, well, that's a question of interpretation. And I think in most cases, as the parties do not agree what they meant by their contract, that's why they are in a conflict, then we have to ask ourselves, what would a reasonable person have thought by using these words? And the wording is one criterion among many others to interpret the intention of the parties or what a reasonable person would have understood. I wouldn't say, usually it's the start of interpretation, but we do not stop there. We don't stop with the wording. If we do have other indications that the parties' intention was different from the wording, then we will use these. But I think the interpretation under the CISG is not much different from interpretation we do in civil law countries. It's a bit different from common law countries, because in common law countries you're not allowed to rely on previous conduct or on subsequent conduct of the parties, whereas under Article 8, Para 3, you have to look at all the circumstances. So there may be circumstances that entirely contradict the wording of the contract and that prevail. So it's all a matter of the circumstances of the case.
Thank you. And the question we have received in the chat while you were speaking is to some extent, I guess, again, answered by your presentation. And that is, does the economic criterion prevail if it contradicts with the intention of the parties? And I assume your answer is no, it's the intention of the parties that can trump the economic criterion.
I would look at both together. Yeah, and sure, if I'm representing the party who wants to have the intent to prevail, then I look at the intent of the parties, and if I'm counsel of the other side, I'm looking at the economic value. So it's always like that. It's different when I'm an arbitrator, then I have to decide. But again, I think there are no hard and fast rules, and we have to look at it as a whole. Economic value on one side, and if the economic value is so clearly 90% to 10%, I think then it's hard to argue that the intent of the parties was different from that. I think the intent is relevant where you have a more or less 50 to 50% situation.
Thank you. And the same question to our co-panelists, if they would like to share their views. And on top of that, if I may add one question, and that is, let's assume that the CSG applies to the licensing agreement on any of the potential bases. Is it well suited to apply or to govern the licensing agreement? What's your take on that subject? Andre, would you like to go first?
Well, as far as the title, the label of the contract is concerned, I'm also of the view that it should play a role while interpreting the contract, while looking for the parties' intent. However, I think there was one explicit case that the labeling of the contract does not decide. And well, it is the prevailing view, for instance, that barter agreements fall outside the scope. If it is so, one could, it is subject to debate, but if it is so, then the parties cannot call their barter contract, the contract for the exchange of goods against goods, a sales contract, and through that make the CISG to automatically apply. I think this would be a choice of law clause rather than a clause that alters the legal qualification of the contract at stake. So I think here one would well, attach great importance to objective criteria, whether it is a sales contract or no. Of course, the parties can frame their contract differently and make out of a barter contract two sales contracts. Well, so far to the labeling. As far as the well, the question is concerned whether the CISG is well suited to govern the licensing agreements. While preparing myself to this panel, I was trying to find, to go through the comparative research. The issues often addressed as problematic for licensing agreements are the battle of forms issues, which are, as is well known, not resolved explicitly by the convention. They might be the answers might be developed under the convention but the convention doesn't address the issues. There are furthermore third-party issues perhaps that are specific for the IP law and not appear in that to that extent in sales contracts. They say that there are several specific interpretation rules concerning licensing agreements. For instance, in case of doubt in favor of licensor. So I think there might be issues that call for answers and that are not resolved by the CISG. But frankly speaking, I'm not so much a licensing lawyer, so I'm afraid I would not be able to identify all of them correctly.
Thank you. Lucas, are you a licensing lawyer, or
no,
would you like to?
I cannot claim to be one, I'm afraid. So, but my reactions to the questions we have been facing is the following. First, I think intent prevails over the economic criterion. And that is primarily for purposes of Article 6. I don't think the economic criterion is used for guidance and is a way of using the convention to its full capacity, but I think parties might opt not to refer to the convention. So I think in context, I would think intent is more important than economic criterion. The second question is the remedies. I think that's perhaps one could call it the $1 million question, or perhaps even more depending on the value of the contract. Given that the CISG, as we know from Articles 4, etc., that it only covers aspects of the sales contracts. It covers certain remedies incredibly well, but might not cover a number of other remedies. So I'm not sure whether the remedies apparatus of the CISG can automatically extend to a licensing contract. I would think a great deal would, but I'm not sure whether everything would be covered. And that's perhaps the broader question mark, and why I would be sometimes hesitant to stretch it to a licensing agreement.
Thank you. Ingeborg, perhaps you have a different view on the topic.
Well, I think the CISG indeed is very well suited for any services agreements and any licensing agreements. If you only look at the UNIDROIT principles and what Lucas is mentioning, especially the remedies part, that was just copied by the UNIDROIT principles. It's copied by many domestic laws now in their general part of obligations. So, I mean, even France that amended its Code Civil in 2016 took the CISG remedies and put it in the general part of the obligations, applying to all contracts, also to license services and licensing agreements. And I cannot think of any remedy that is not existent in the CISG that we were to need for licensing agreements. So I think especially, well, let alone formation of contract. I mean, formation of contract is general contract law that has been copied also by the UNIDROIT principles, applying to all contracts now in the UNIDROIT principles. So especially formation of contract, breach of contract, and remedies for breach of contract, I think are very well suited. And I think this Swissmoot's problem with Article 42 shows us that especially the CISG is better suited than any domestic legal system, because the CISG distinguishes between encumbrance with third-party rights, property rights, and encumbrance with third-party intellectual property rights, which is very different, especially on an international level.
Thank you. But I'm just thinking about the distribution agreements as well, which was one of the topics of controversy, whether the CISG applies on distribution framework agreements, not on the specific sales being made under the framework agreement. And if I'm not mistaken, the predominant view still is that the framework agreement on distribution is not covered by the CISG, whereas the individual sales are. So would you like to tell us about this particular point in doctrine and case law, and maybe make a distinction? Why do we think that the CISG is not well suited then for the distribution agreements, where it may be well suited for the licensing agreements?
Well, indeed, the still prevailing view is that we should not apply the CISG to the framework contract, because there are different obligations beyond sales obligations, but there is case law actually applying the CISG to framework contracts and to distributorship agreements. And I'm very much in favor of applying the CISG to distributorship agreements. I once had a case as an arbitrator, for example, that was during the economic crisis, where the buyer refused to take delivery and to pay for the goods under a distributorship agreement, because the market had broken down and it could not on-sell the goods, luxury watches, on the American market anymore. So it was clear that we had to discuss the question of hardship concerning this individual sale. And the question was now, how does this hardship concerning the individual sale impact the whole distributorship agreement? And if you are using different laws, for example, a law that has a higher threshold for hardship for the distributorship agreement, then you use it for the individual sales contract, then there will be frictions. And it doesn't make sense to say, well, the buyer is exempted as regards the individual sales contract under the distributorship agreement, but it's not exempted as regards the whole framework contract. So I think applying the CISG to the framework contract, to the distributorship agreement, relieves us from problems of coordinating different laws.
Thank you. And this again takes us to one of the questions from the chat, which where an inquiry is being made by one of our observers on your arbitration practice. Ingeborg has just shared an example from her practice where some of these complicated issues regarding CSG has been answered in the way she proposed. Andre, Lucas, do you have an interesting case from your arbitration practice to share on the topic of either licensing agreements as such or the CSG scope of application? Andre does not feel like having something to contribute on this specific topic, but Lucas, would your answer be different?
I think for better or worse, the fact is that in several of the international contracts I have arbitrated, parties have expressly excluded the application of the CSG. There is also a couple of cases where I have been an arbitrator where the parties have debated the arbitration of the CSG, and it was also, for example, even in relation to state contracts, which is a very interesting aspect that the CSG obviously did not originally dissipate state contracts for of certain significance. And I think there's also a couple of cases where I have seen that counsel has not been trained, particularly in the CSG. Although the CSG, in the eyes of the tribunal, was applicable, they would not even bring it to the tribunal, and then the tribunal had to be sort of nagging the parties, the lawyers, whether they have exhausted their arguments or whether they make any additional submissions. And in one or two occasions, we even had to expressly say, would you consider that as a point? Can we have submissions on that? So that also shows a level of asymmetry and perhaps a bit of lack of awareness in certain practitioners' cycles. I think the younger generation, particularly the ones who have gone through the moot, have a different view. But in the cases where I have had licensing arrangements, and I have had them in a couple of matters, the parties have engaged in what we will call a very long regulatory contract, and they would leave very little to be decided by operation of the law.
Thank you. And again, we are still walking on those boundaries of judges deciding the cases and arbitrators deciding the cases, and pointing out to differences to approaches on the point of applicable law in those two instances. And I was wondering, to what extent would you say that party autonomy plays a role in cases where no applicable law has been agreed upon in the contract, but the parties are pleading on the basis of national law, excluding the CSG, where otherwise it should have been applied, or vice versa, of pleading on the basis of CSG, where a different national law perhaps would have been applied by means of private international law? How do you interpret? I mean, do you see an implied agreement on CSG or an implied agreement excluding the CSG in any of those two scenarios? Or what would be your advice? Is there a difference, again, in courtroom or with the arbitration tribunal? Ingeborg, would you like to go first?
Well, the question is pleading the wrong law, is that an implicit choice of law? And I have one answer to this question. Ignorance cannot be a choice of law. Yeah. So if the parties plead the wrong law, especially in court proceedings, then the court must apply the applicable law, because that's not a valid choice of law. And that is now also mostly held in most jurisdictions. Well, not in all, like the French Cour de Cassation doesn't follow this approach. They stick to the position that if the parties have pleaded French law, this is an implicit choice of French law in court, even if they did not know that the CISG applies. So I think that's wrong. And the CISG Advisory Council also has issued an opinion on opting out from the CISG, and we clearly stated that pleading the wrong law, not knowing that the CISG applies, certainly is not an opting out from the CISG. In arbitration, I think it is up to the tribunal to discuss, as Lucas mentioned, to discuss with the parties whether they consider that there might be another law to apply, and they have to voice whether they want the CISG to apply. If they insist that they do not want, both insist that they do not want to apply the CISG, then that's a valid opting out from the CISG, certainly.
Thank you, but let's imagine the opposite situation. Let's imagine a situation where parties are not trying to opt out of CISG, but actually to opt in by pleading what seems to be the wrong law on its face. Let's imagine a situation where the CISG would perhaps be part of the applicable German law, and the German court decides that it does not apply to licensing agreement. Yet in the proceedings, the parties are pleading on the basis of the CISG. Would you say that the same answer applies, or would you see it differently?
If the parties agree that the CISG should apply, actually in courts, that would amount to a choice of law. And in German courts, for example, and in many European courts, unlike in Russia, obviously, this is not possible, because if the CISG does not apply, then the CISG are dealt with as rules of law. And under European private international law, the parties cannot choose rules of law in a domestic court. So, and this is, as Lucas pointed out, this is different in arbitration, where you can always choose rules of law, and then an arbitral tribunal certainly would apply the CISG.
Thank you. Andre, would you like to contribute to this debate?
I just perfectly agree that you can't expressly opt out without knowing what you are doing. So in order to construe the party's behavior as an opting out, you should presuppose that parties behaved this way, so pleaded disregarding the CISG, knowing that the CISG actually would apply. If not, then one would be generally inclined to not to see their behavior as an express opt-out agreement.
Thank you. One comment for the audience. We have 8 minutes left for this panel discussion, so feel free to ask additional questions, if any. Before I ask my final question to all the panelists, Lucas included, and you can go first this time, and that is, does the CISG provide new rules for vaccines?
I think just a small comment on the discussion we have had before, and that is sort of the evolution of the doctrine of jura novit curia, the judge knows the law, and therefore it may or may not matter what the parties bring to the court, because ultimately in a domestic court system, it's critical for the judge to be able to bring in the law. In arbitration, of course, is a bit debated as to whether jura novit arbiter, and we have seen a couple of years ago, two, three years ago, the development of the Prague rules, which were supposed to almost codify a jura novit arbiter system in arbitration, and there has been quite a bit of reluctance, and eventually this was a bit watered down. I said earlier on your question as to whether the CISG provides rules for vaccines, I said that the CISG is the result of a long negotiation process by a number of genuinely enlightened scholars and practitioners. And although people sometimes say that every treaty of that type is a compromise, in all possible respects, the CISG is a very wealthy document in ideas, structures, methodologies that are built in order to get where you need to get it. And I have also indicated that I think there is a scope for dynamic interpretation. would the CISG as is provide particular new rules for vaccines? That I'm not entirely sure. I think a cynical view would be that vaccines is ultimately a medical question or a biomedicine question and less of a legal question. But certainly a lot of the, and if you see, for example, the debate that has been had about the acquisition of vaccines by the European Union and the European Commission and the choice of Belgian law as the law governing this agreement, Belgium is a CISG country, of course, brings also an interesting debate, because obviously the Commission, the European Commission that is, felt that that might be a way forward. And that's perhaps enough said about Europe.
Thank you. Ingeborg, what do you think?
Well, I think the CISG does not provide new rules. It's the rules we always have. And the CISG applies to vaccines. The CISG is apt to apply to software. So the answer is no. No, there are no new rules, but the CISG is suited also for vaccines.
Thank you. Andrei, you have the last word on the topic.
Well, even if new rules for vaccines in one aspect or another would be needed, they are not there, and they would be too long to expect, too long to wait for. The CISG is there, and one might have debate on whether it fully covers all the issues that are raised by the nature of the contract. But anyway, CISG is suitable to govern this contract, while there is no alternative in the near future that would do that in the uniform and balanced way. That would be my political statement.
Thank you. And I'm happy that we are ending this panel on a positive tone. CISG is here. It contains no new rules for vaccines, but the rules have been there for 40 years already, and they are ready to be used. We don't have to wait. We don't have to wait for another years or two for new rules, right? It's there and should be used. And let's see what the future will bring and to what extent it will be used in practice. I would like to use this opportunity once again to thank all my three co-panelists today for their insightful opinions and comments on the topic. I would like to thank the host for inviting us here and for giving me this honor and pleasure of moderating this wonderful panel today with you. Good luck to all the participants of the Moscow Pre-Moot, and good luck to all the mooties in the world. Thank you.
Thank you and goodbye.
Good luck. Thank you.
Good evening or good afternoon, good morning from where you are joining, and welcome to the last session of today's conference. My name is Nadine Lederer. I'm a senior associate in the international arbitration team of Hogan Lovells in Munich, Germany, and it's my pleasure to moderate tonight's session, which will deal with the scope of exclusive licenses, a right of use without third-party rights or claims. And I'm very pleased to introduce our two distinguished speakers. We have on our panel Dr. Dorothee Schramm and Boris Malachov. They are both very experienced practitioners in IP-related disputes in the pharma industry. And Dorothee is a partner with Sidley Austin in Geneva. There she's part of the arbitration and disputes team, and she has particular experience in technology and life science disputes, including in particular pharmaceuticals and biotech and medtech. She's not only acting as counsel in arbitration proceedings, but also is regularly appointed as arbitrator. And her work mainly includes a broad range of transactions, including also commercializing intellectual property, like licensing and cross-licensing agreements and collaboration and partnership agreements. Our other speaker is Boris. He's a partner in the intellectual property practice of Leadings in Moscow, and he specializes in particular in IP-related disputes and has built experience, especially in proceedings involving companies in the pharma and healthcare sector. He's focused on representing his clients in disputes about infringements of various IP rights, including patents, trademarks, and design rights. And we will basically have three sessions in this panel discussion. First, Boris will start with a short presentation on the scope of licenses, and this will be followed by a second presentation by Dorothee, who will deal with third-party effects of exclusive licenses. And I will now give the floor to Boris. He will tell us more about the different kind of licenses. There are different kinds like exclusive, non-exclusive, and sole licenses. And I hope that Boris will shed some light on this and give us a better understanding how the different licenses work.
All right, thank you, Nadine. Hello, everyone who's watching us, who's interested in arbitration, in intellectual property. So I really think that you will enjoy the session because Nadine, Dorothee, and a little bit of me are really full of energy to share our experience of how the licensing policy works in this field of healthcare and life sciences. Personally, me, I'm a partner in a Moscow-based law firm, and I mainly deal with healthcare sector in transactions, in litigations, in enforcement cases. So in my brief presentation, I have a few slides. Right now, they are on the screen. So I will share some basic issues on what types of license exist, how do we work with them, and what particular attention should be focused when you have a deal on licensing patent rights to another party. So I would start with the types of licenses. In real business, there are a few types of licenses which usually parties enter into before manufacturing, sales, marketing of the product. Mainly, the licenses are divided into two types. There are exclusive license, when no one but the licensee or the licensor means that there are only one party which may use the patent, the trademark, copyright, and so on and so forth. and no one retains the right to use it. Apart from that, non-exclusive license gives a right to a licensor to license their intellectual property assets, patent, trademark, copyright to every person, to every company it thinks appropriate. So the main difference is that an exclusive licensee has a right to use the asset, has a right to enforce it against other parties, has a vast majority in how to commercialize the asset. So, and in this, particularly in this field of life sciences, licenses are indeed a key element of how to build very prosperous business. Because apart from other industries, I know, machinery, energy, and so on and so forth, in life sciences, you simply don't have money if you don't have a patent right. Because patents usually exist not only to have a paper where you are assigned as an inventor and owner of some invention. This is the legal document which gives you a legal monopoly to use and to market and to commercialize your technology. So quite often in the sphere of life sciences, for some drugs, a patent owner has to spend billions of dollars to get a patent, to conduct research and development of the drug, and after those stages to let the drug enter into the market. So the patent is a guarantee, is a legal guarantee of how to save those billions of dollars spent for research and development of the drug. It's just the only guarantee of the legal system that your investment in the knowledge, in the technology, would result you in some benefit. So the license is the only way how to commercialize your technology, especially if you are a developing startup which doesn't have facilities, doesn't have premises, doesn't have sufficient staff to commercialize your technology. License is the only way for you how to attract money to your business. So, and the licenses vary, as I mentioned before. There are a few types of licenses: exclusive, non-exclusive. Each type of that gives you various scope of rights. And in the life sciences business, in life science business, the particular clauses which you insert into your license agreement depend on a few factors. So the first is the market, where you would commercialialize your invention. Because licenses vary from market to market, this is not a secret. Sometimes drugs in one jurisdiction significantly differs in its price from another jurisdiction 10, 100,000 times, and this is based on the internal policy of the particular market, of the particular jurisdiction. Because to license the drug should be economically beneficial for you. That's why you have to take care various circumstances, competition level on the market, and of course regulatory framework in the jurisdiction. Because if you have your business localized, of course the rate of royalties, the type of the license would be more favorable for you. If you have excessive regulatory requirements like local trial studies, very weak data exclusivity status of the drug, very weak enforcement system in the state, so it would evidentially influence your license type. So the fees and the conditions of the license greatly depend on the type of the license. For exclusive licenses, of course, royalties are higher and the warranties are stronger, and the contract is more on the side of the licensee. Duration of the license agreement is also a factor, because apart from many other market business niche, there is a rule in the life sciences that the longer the license is enforced, the higher the royalty might be. It means that the drug becomes more and more beneficial for the patent holder, for the licensee, as far as it is on the market. I mean that the patent holders, the marketing authorization holders, they're the companies which really produce and control the drug on the market. They spend much budgets, very huge sums to promote the drug, to achieve, regulatory approvals. So it means that the longer the drug is on the market, the higher sales are, the more beneficial the drug is. So the duration is a key factor. And of course, technology. This is not a secret for anyone that the patents, they never describe the technology itself. When it comes to biological drugs, like the vaccines, biosimilar drugs, many other types of drugs produce the biological formulation in the patent. This is not a secret that technology of production of this biological drug is even more important than the drug itself. It means that the technology plays a key role, and commercialization of biological drugs severely depends on technology. Technology is never expressly described in the patent. This is not a secret. This is not a secret either, because quite often technology is saved and kept confidential, and protected by not by patents which are publicly accessible, which lay in open data. So they are quite often protected by know-how, trade secrets, which never get accessible for public. That means that sometimes the patent protects only a very minor part of technology, and the key license issue lies in the sphere of trade secrets and know-how. So sometimes you see the patent, but you simply don't know what it protects, because the major part of the technology is hidden in know-how and trade secrets, and this is also should be taken into consideration. So based on the factual background of the case, I just tried to describe on the slide how the license issue is governed between a few companies, Vectorvir, Camvir on the one hand, and Rospharma and Respifac as licensees. So in first license between Vectorvir and Rospharm, this is a clear exclusive license, which is made for malaria and related infectious disease. Apart from that, Camvir, which got the exclusive license from Vectorvir, gave a non-exclusive license to Respivac, so for respiratory disease. And I don't want to comment the substantial background of the case, but from the first glance, you see that the scope of the licenses seems a little bit similar. In both cases, the licenses are made for diseases. In the first exclusive license, dated June 2014, it is made for malaria and infectious disease. The non-exclusive license 5 years later is made for respiratory disease, and both relate to COVID infection. So from the first glance, it seems that the scope of the license is confusing. I mean, malaria and related infectious disease. How would the company give so wide right to any related infectious disease, which are the list of infectious disease is very long. So, and probably it's open-ended, because more and more infectious disease can appear in the future. But my answer as a practical lawyer working in the sphere of life sciences is that this is quite usual. If you look at the clause 1.3 from the legal problem of this year, from the first glance, again, it seems that the clause, the field definition of field is very, very wide. But on the same slide, I found a very similar clause in one of my recent license contract. Of course, I removed some very confidential part from that citation of point 1.5 from my recent contract, where the field is also described very, very, very broadly. So the invention in my particular contract, in this particular contract, the license was made for the product, for the product curing any kind of pain. So the definition was really broad, and this is quite usual for the pharmaceutical industry. People here always try to save more rights and try to license as less rights as possible. So it makes them to draft contracts in such a way. I mean, this is the version of our licensee who would want to get a license for treatment of any pain, including cough, neuropathic pains, and so on and so forth. So, but that's quite that reflects how the people work there. So, in the scope of licenses, people not only tend to to define particular diseases, as was made in this particular case, but also some therapeutic effects. So I would say that the license presented in the Moot case this year was a rather moderate comparing to what we usually have on the market. That means that you have to be very careful about terminology in your license agreement, and to be more accurate in wording, to be more certain in legal terminology. I also in my practice, I also try not only to refer to some diseases, but also to international classification of diseases. This is an international classification made by World Health Organization, which has records of particular all known diseases with the numbers, with the names, and that would be very helpful. If after the Moot you will decide that you lost your interest in arbitration and want to become an IP lawyer, this is quite reasonable. And believe me, this was my path in the legal career. So I started as an international arbitration lawyer and then switch entirely to intellectual property. So if you decide to do the same, so I would recommend you to refer to International Classification of Diseases in your documents. I would also refer you to, advise you to use the World Health Organization bulletins and recommendations on various diseases, where you may see what diseases are regarded infectious, and so on and so forth. This is also very helpful. And I would also advise you to study pre-trial studies documents and scientific data, because no drugs have ever been licensed or commercialized without the drug going through at least a pre-trial studies. Pre-trial studies gives scientists a notion of whether the drug has potential or not. Because in 99% of the cases, scientists lose interest in the drug during the pre-trial studies. The pre-trial study is the only way to understand whether there is potential in a particular drug. So you have to carefully, or your scientific staff of your client or your law firm, you have to, for example, patent attorneys, they have to check pre-trial studies and scientific data to understand what should be the scope of the license. And probably the last thing I want to attract your attention to is that the patents vastly dependent on very numerous encumbrances. So I mean that in the present case, there is the issue if the exclusive license touches upon the non-exclusive license issued later, whether there is a dependence between two types of license, how would one influence another, and so on and so forth. So in the sphere of life sciences, patents are also always a key asset for the company. So the companies try to get as much as possible from the patent. So they license their products. When it comes to some technology brands and so on, they also franchise it. So the particular license clauses are often envisaged in the distribution agreements with some local companies. So those types of agreements, I mean, licenses, franchises, distribution agreements, they are encumbrances which may have effect on your later license agreements, and you have to take care of it because it can significantly narrow your rights for further licensing of your patents. But you also have to take into consideration that in some jurisdiction, not only the agreements but some consent letters also may give rights to other parties to use your invention. So in those consent letters, the patent holder may unilaterally authorize to use the patent for a few years for a certain type of industry, for a certain type of marketing and sales company. So those consent letters never appear publicly, but they may give the right to use the patent for some third parties as well. And you will never know about it during negotiations of your particular license contract. So, but you have to make your licensor disclose this information on every license, franchise, distribution agreement, consent letter which they have, because it really has vast impact on your future business. The same relates to pledges and joint ventures. they are encumbrances which also very important and should be disclosed before you go, before you enter into your license agreement. And probably the due diligence is the only thing where you can find a vast majority of this information from the publicly available databases of the Patent Office, of the Ministry of Health databases, from the publicly available databases of drugs on the website of the World Health Organization. But of course, during your due diligence, you have to make your partner disclose as much information as possible. In this particular case, I saw that due diligence was made not perfectly. I hope that in your future practice, you would do it better. Thank you.
Thank you very much, Baris, for giving us such a good overview of the different types of licenses and also for sharing your practical experience with us. We will now turn to Dorothy for the second presentation of this session. She will focus on the third-party effects of exclusive licenses and deal with Article 42 of the CISG, which is one of the main provisions in the Moot case this year. And she will give us an understanding of the different scenarios in which a claim may exist against the third-party infringer and a third-party licensee. So Dorothy, the floor is yours. Thank you.
Thank you very much, Nadine. So yes, my topic for tonight is third-party effects of exclusive licenses, which is something that's very important. Now, my topic was kind of born out of my observations at some of the pre-moots, where I saw that there might still be a little bit of confusion of what an exclusive license can do and can't do vis-a-vis third parties. So I thought it might be useful to have a look at this in a little bit more detail. So the starting point for everyone on this call is Article 42 of the CISG, especially paragraph 1, which says that the seller must deliver goods which are free from any right or claim of a third party based on intellectual property. Now, in order for you to make really convincing arguments on what might be a relevant right or claim, I thought it's useful to have a little bit of an overview of different scenarios, between different patents and patent licenses in the IP arena. Now, obviously, the starting point is a patent. That's the most important, probably the most important intellectual property in the life sciences area, along with know-how and others. But patents are really important. So you have the patent and the patent holder. And that patent gives the patent holder the right to use the invention and to be the only one to use it. So it's an exclusivity right. But of course, the patent holder can then enter into an exclusive license agreement with the exclusive licensee. And that now makes the exclusive licensee kind of participate in the patent. And now it's the exclusive licensee that has exclusive right to use that invention. Now, there are differences between exclusive licenses and sole licenses. Under an exclusive license, only the exclusive licensee has the right to use the patent. Not even the patent holder itself is allowed to continue using it. Whereas under a sole license, it would typically, the patent holder keeps the right to use the license itself, but the only other third party that may use it would be the sole that is a relevant difference, not really directly relevant in the Moot case. You can assume that it is an exclusive license, but in many contracts, it's not actually clear what is meant, and sometimes they're calling it an exclusive license, even though what they had in mind was actually only a sole license. Now, what is an exclusive license agreement? The starting point is it is a contract. And as you know, contracts typically have only effects between the two contract partners. So only between those that are parties to the contract. However, that would not make much of an exclusivity here. So there are exceptions, and the exclusive license is a contract that has certain exceptions, in that it can have certain third-party effects. And one example is if the patent holder sells the patent to somebody else and transfers it, under many laws, the exclusive licensee will keep the right to use the patent even when it's with a new patent holder. Now that is, a very, it's something that other contracts can't do, but an exclusive license can do under certain applicable laws. When, sometimes it's required that you have the exclusive license registered in the patent register. That would be the normal case. But in our case here in the Moot, we don't actually know whether the exclusive license is registered, and I don't think it makes much of a difference here. Now, what about claims against third parties? Let's first look at the case where we have a third-party infringer. So you have the patent, you have the patent holder, and you have a third party that uses the patent without entitlement and so infringes the patent. Now, obviously, the patent holder has a claim against the infringer, an infringement claim. And that can be, that the infringer stops the infringement. It can be a claim for damages. It can be a claim for profits made with the infringement. Depending on the applicable laws, such a claim can take various shapes. Now, what's the situation like now in the case of an exclusive licensee? Now, does the exclusive licensee have a claim against the infringer A, even though the exclusive licensee only has a contract right? Now, the answer to that question really depends on what law applies to the license agreement and what law governs the exclusive license. But under many national laws, you have such a claim directly by the exclusive licensee against the infringer. Now, there are various requirements that really depend on the applicable law. Under some laws, it's required that this direct right to claim is not excluded in the license. Some applicable laws require that you have consent by the patent holder. Others only require that the licensee gives a notice to the patent holder before it sues the infringer, or that the patent holder has failed to sue the infringer itself. So it really depends what law applies. And also the way how the different laws kind of justify this anomaly that a contract party can sue a third party based on a contract right. In certain jurisdictions, the exclusive license is considered almost an in rem right, like property in a way. In other jurisdictions operate with the concept of procedural substitution, so that the licensee kind of steps into the shoes of the patent holder. And oftentimes, this claim only exists for an exclusive licensee and not, for example, for a sole licensee that I addressed earlier. Now that, this difference between in rem kind of justifications and procedural substitution is somewhat relevant for you to understand the second scenario. And that's the scenario I know you are most interested in. That is now, what about claims against a third-party licensee? So here you have the situation that a patent holder has a license agreement with a licensee B. It can be a sole license, an exclusive license, doesn't matter. Many times licensee B will then sub-license it to somebody else, and you might have a chain of contracts. But obviously, in such a case, the patent holder can't sue the licensee for patent infringement. That's very obvious. And just the same, it couldn't, what if the licensee B sub-licenses another party, then the patent holder couldn't sue that party either for patent infringement. Now, what now in the situation of the exclusive licensee? Now, does the exclusive licensee, which in our case is Ross, would that licensee have a right to sue a third party, which is licensed directly or indirectly by the patent holder? Is there such a claim? Now, the answer is, as before, it depends on the applicable law, the law that is governing the license. But under most laws, I can tell you that typically there is no such claim because the licensee B is validly licensed by the patent holder. So, what we have here is a scenario, assuming, all these licenses cover the same scope, and Boris addressed that earlier. You would have a case where the patent holder breached the exclusive license by granting another license to a third party. But, in case of breach of contract, typically what you have to do is you have to turn to your contract partner, but you can't go and claim, make a claim against your contract partner, contract partner. So in this case, the licensee B. So, in most cases, such a claim, direct claim, does not exist. There are exceptions. For example, under competition law, if the licensee B was fully aware of the exclusive license and was really pushing the patent holder to breach its contract with the exclusive licensee, in such cases, you might have a claim based on competition law. And under some, maybe some laws governing licenses where there is an in rem effect, you might have under such laws maybe an exception that would consider the second license to be not fully valid depending on knowledge. But that is really the exception. The rule is there is no such direct claim. Now, what does that mean now for Article 42, paragraph 1 of the CISG? Now, for me, a right or a claim of a third party in this case does typically not exist. We do, depending on the law governing the license, but typically such a claim or right would not exist. So that raises really then the question, does the claim have to really be justified under Article 42? Or is it enough that it is just asserted by the third part, by the exclusive licensee? Now that is obviously a tricky issue. I'm not going to go now into the CISG and all the jurisprudence that you all know a lot better than I do, actually, in all its details. From my personal perspective, if you buy, just in terms of the rationale behind that provision, and that is, what's most relevant for me. If you purchase a good, you're not typically accepting to purchase a legal dispute. That's typically not part of the deal. So, if a claim is asserted against you and you're being dragged into a litigation, then for me, that would fall under Article 42 when looking at the rationale of the provision and without regard now to the commentaries and court decisions. And then, of course, that leads to the next question, and that I leave totally to you, as to how clearly asserted does the claim have to be? Does it have to be already threatened? Does it have to be only lingering in the background? What is this threshold here? Now that is a topic that I will leave to you that goes now very deep into the CISG. But what for me is important is that you understand a little bit of the functioning of an exclusive license vis-a-vis third parties and what a license can and can't do. And that is all from my side.
Thank you, Dorothy, for explaining us the different scenarios and giving us a good overview about the different claims that may exist. Well, we have still some time left, and I would encourage everybody to submit questions in case you have any. I would start with a question to Baris. Thanks again for explaining us the different kinds of licenses. Maybe you can give us some more practical background from your experience, what pharmaceutical companies usually consider when determining what kind of license they are licensing to a party.
Okay. Frankly speaking, they decide on how would they benefit more from the deal. So it constantly depends on the commercial obligations of the party, commercial conditions of the contract. So, but quite typically, for the drug to be commercialized on the national market, an exclusive license is required. Not only because this is quite rational from the commercial side, but also because a licensee has to do much work itself to register a drug, to get through clinical studies, because in many jurisdictions, not in Europe, but in Asia, in Western Europe, you have to go through local clinical studies. So you have to go through a very lengthy mechanism of marketing authorization on the market. To do all of this, you have to be a licensee and you have to be ensured that you are the only person, you are the only company which would benefit from the patent. So I would say that an exclusive license is a very typical for commercializing a drug. So Dorothy, in your experience, how would you assess what other factors also play a role in the type of license to be chosen?
Well, I think, I think you hit upon the most important points. So I think you captured it.
All right, and probably the only thing I would add that, in this particular case, as I saw in the clarifications to the problem, the patent to that technology was made effective in almost every jurisdiction worldwide. So for those types of products which gonna be commercialized in every state, so quite often an exclusive type of license applies on the national level.
Thank you both for your answers. Well, I would conclude then with a final question, probably first to Dorothy, and Baris can add if he has any further comments. So a lot of contracts include warranties that the respective goods are free from claims or free from infringing any third-party rights. Maybe you can share from your practical experience what's the purpose of such warranties.
Well, I mean, it's of course, that you get the freedom to operate, that you can make, if you enter into a contract, whatever contract that may be, you want to avoid that you are finding yourself on the receiving end of an IP infringement claim, because these claims are, if there is an intellectual property right attaching to whatever you're purchasing, for example, that means you might not be allowed to sell or use it anymore. You might have to destroy what's there. You might have to pay damages. It's a very, it defeats the entire purpose. But on the other hand, you might not have always full visibility into what IP rights might attach to that. Because it might sound simple in theory, but it's actually quite complicated in practice to find out what IP rights might exist. I mean, patents, at least you have patent registers, but even there, there are so many, the patents are phrased and the inventions are phrased in quite an abstract way. It's doing a patent search to see whether there's any patent that could attach to whatever you're purchasing. That's a real undertaking. It's very expensive. When it comes to then, exclusive licenses or, that might be even more impossible. When it comes to know-how, that, of course, it's something that is not even registered anywhere. So it really depends. So these claims can be very costly to litigate. They can be very damaging for your business. And therefore, you have no direct insight into it. And therefore, that's why you put it in a representation warranties clause, so that if all of a sudden you get a claim from a third party, at least you can turn to your contract partner and say, hey, here, I'm on the receiving end of this claim, and you are the person who has to either take over that claim from me or indemnify me, or I can withdraw from the contract, or whatever the consequence might be. But just a word of caution, oftentimes, it is a rep and warranty, but what is the remedy you have, if it's not clear in the contract, might not be as straightforward as it sounds. So that's something that is important for whatever type of contract you conclude. You better put it in the contract.
Thank you, Dorothy. Baris, do you want anything to add?
Yeah, I totally agree with Dorothy, and I would also once again underline that quite often patents are only an insignificant part of the deal. So technologies quite often are hidden in know-how, in trade secrets, and because they are not publicly accessible, as Dorothy said. So the patent is only a cherry on the cake. So, but the most delicious one, and of course you have to be very careful about that. So, and I recall from the book of Harry Potter, the Half-Blood Prince, my favorite part. There was a charm called Unbreakable Vow. It means that any wizard who breaks his promise immediately dies because of this charm. So in life sciences, this unbreakable vow doesn't exist. Companies tend to push more on their contractors to get much from the license agreement and to give in return as less as possible. So it means that during almost every deal in the sphere of license of very front technologies, they always would raise concerns about the scope, about the rights, about the guarantees, and probably the arbitration practitioners would give particular concern to those kinds of disputes. I don't think that the problem came out of nowhere this year. Of course, this reflects how the market works and how controversial the sphere of life sciences and licensing is.
Thank you, Baris. Well, I would say then I'm seeing our time is almost over. Thank you very much again to our two panelists. I think we got two very insightful presentations, and all the thank you to all participants of today's conference, and I wish all students best of luck for the WIS Pre-Moot tomorrow in Moscow and on Sunday, and enjoy the experience and have fun. And as said, best of luck for your pleadings. And that's all from my side. And thanks again for a very good discussion tonight.
Thank you, Nadine. It was a pleasure. And good luck to everyone.
Good luck.